Hello and good afternoon to those of you streaming in. We'll get started shortly. Thank you for being with us today. While we're waiting on the masses, I'll just take a moment to plug some upcoming additional programming that we have on the topic of immigration. On April 23rd, we have AI surveillance and immigration in 2026, legal risks, due process, and emerging practice challenges. We also have an immigration and employment law program coming up on May 7th. And then we have a mid-year immigration roundup on June 10th, which is crazy that we're almost in June. So I will send a link to all of those programs when we're done here, but just wanted to take a moment and plug all of the amazing work our international law section is doing this year. We're about a minute in. I know we have a lot to cover, so I don't want to delay things further. I know people are still kind of trickling in here, but let's go ahead and get started. Good afternoon, everyone. My name is Domenica Essie. I'm the education manager here at the Cleveland Metropolitan Bar Association. Thank you for tuning into today's program, eligible for 1 hour of CLE credit. In order to get that credit, you have to do two things: complete the poll that will appear on screen during the session today, and complete the survey, which will be emailed to you upon conclusion. I will also be sure to email the materials upon conclusion as well. If you have any questions, you can drop them into the chat or the Q&A at the bottom of your screen. We'll do our best to address those questions as they come in, or more so towards the end. So with that, it's my pleasure to turn it over to Adrian Coppola, who is on the International Law Section's Executive Council and working very hard to put together all of these programs for the CMBA. We really appreciate all of the work that you're putting into this year, Adrian. You're also the supervising attorney with Catholic Legal Immigration Network Incorporated, or Clinic. You're very busy, and again, really appreciate your time. I'll turn it over to you to introduce this program. Thank you.
Thank you, Dominica, and thank you everyone for being here today. I'm glad to see such a good turnout, especially because we know that not everyone here practices immigration law, and that's actually part of why we wanted to offer this session. Because over the past year, we've seen a significant increase in immigration detention, along with more limitations on access to bond and fewer procedural protections in immigration court. And as a result, habeas corpus has become one of the most important and sometimes the only tool available to challenge unlawful detention. And because of that, there is a growing need for attorneys, including those outside of traditional immigration practice, to understand how habeas works in this context and where they might be able to step in, whether that's through pro bono work, collaboration, or broader advocacy. So today's training, it's called Immigration Habeas 101, Foundations, Strategy, and Procedures, is really designed to give you a practical foundation and help demystify the area of habeas. So I'm going to briefly introduce our two presenters today. We have Russell Aberton, and he's an attorney at Aberton Law in Michigan. He's a past chair of AILA Michigan, of the AILA Michigan chapter, and a former member of AILA's National Board of Governors. He has extensive experience in immigration litigation, including published cases in the federal circuit courts and the BIA, and he's received multiple AILA awards for his contributions to the field. And we also have Brian Hoffman. He's the founding executive director of the Ohio Center for Strategic Immigration Litigation and Outreach, which focuses on providing free legal services to individuals in immigration detention. And he has led major pro bono efforts representing detained asylum seekers and has been widely recognized in national media for his work. We're very lucky to have both of them here with us today. And with that, I'm going to turn it over to Russell and Brian to get us started. Thank you.
Thanks, Adrian. Do you want me to run through the agenda, or is that on somebody else's plate? Because I've got the immigration habeas basics queued up on my practice slide.
You can go ahead and run through the agenda, Brian. Thank you.
Sure. So yeah, we're going to talk about the immigration and habeas basics, and then the key issue right now is this distinction between whether someone is detained under Title 8 USC 1225 or Title 8 USC 1226. I will be getting into that in some more detail later. There's a variety of situations where you would want to file a habeas petition, such as your client was reporting to an ICE check-in and was detained. Your client was detained for a traffic violation. Your client is being flown across the Atlantic Ocean as we speak. So there are types of habeas petitions that are less common. We'll spend a little bit of time on those. And then we want to give you some Ohio-specific resources. The Northern and Southern districts of Ohio each have their own quirks and idiosyncrasies about how they like things. Um, the bread and butter of my practice for 15 years has been working with people who are currently in jail. So we'll give you a little bit of information on the issues working with ICE detainees and how to help with language access issues. And then Russell has some great info for us on how to work with volunteer projects in Michigan. The center that I founded in 2020, Auxilio, is actually hiring right now, and we're hiring specifically for someone to help with habeas corpus petitions. So if anybody wants a change of career and wants to get into doing specifically this for their full-time job, please shoot me an email. So as we go on to the next couple of slides, then I'm going to start out with a little bit of Ohio geography. Like a lot of immigration lawyers, I've worked at and with a bunch of different nonprofits and was in private practice for a while, and also had the opportunity to work on some national service projects, mostly in South Texas. So our Ohio geography is actually not well understood by people who are not from Ohio. It seems like it's a small state, and in fact, you could spend your entire day just driving around to the various courts and detention centers to see your clients. So we've got about 6 ICE detention centers now. Most of them are in the Northern District of Ohio. So those are the Seneca County Jail in Tiffin, the Geauga County Safety Center in Chardon, CCNO, the Northeast Ohio Correctional Center, and the Mahoning County Jail. The Northeast Ohio Correctional Center is privately owned. It's operated by CoreCivic. The others are county jails. And if you are familiar with Northern Ohio, the Geauga County Safety Center is by far the best place to be detained if you have to be detained somewhere. They're very easy to work with. It's a very clean facility. The Southern District of Ohio is home to the Butler County Jail, which is one of the most notorious facilities in Ohio for lack of care and violation of standards. But so unless you represent somebody in Butler, you'll be filing in the Northern District of Ohio because that's where all of our other detention centers are. Now, there are periods of time where people sort of disappear into the cracks. There are various ICE and Border Patrol offices and facilities throughout Ohio. So often you will have a client picked up, say, in a traffic enforcement action who maybe for a couple days is not locatable via the standard means because they're being processed by ICE or Border Patrol and they're not in an official detention center yet. So we'll talk a little bit later about how to try to locate some of those folks. But it's very rare that I have a client call me while they're actually being detained or being processed. Occasionally, I get a client who says, hey, I was able to get my cell phone out of my pocket and I'm in the ICE office right now. But most of the time, it's when the client is already in an ICE detention center and usually has been there for a few days that we find out about the case. So the next slide has just kind of the statutory bases for why someone is in immigration detention. Like I said, the big debate right now is whether 226A or 235B apply, and we'll get into that in detail later. But one thing to flag right away is that there are a whole bunch of statutes that say that you have no access to get out of jail, that you are mandatorily detained. And those are largely about document fraud, terrorism, controlled substances, aggravated felonies. But then we had one of our only actual changes to immigration statutes in the recent history, the Lake and Riley Act, which also made you subject to mandatory detention if you were arrested for certain offenses. The trick there is that we have seen ICE taking people into custody and arguing that they are mandatorily detained with no option to to be released, even if they were arrested for a theft offense years ago that was later dropped by the prosecutor or that they were later not convicted of. So the word arrest under Lake and Riley is being used really broadly to argue that lots and lots of people are mandatorily detained. And there's a lot of litigation over what does and doesn't constitute a triggering act for Lake and Riley. Uh, so a lot of times the clients that you're going to be working with don't really have these high-level terrorism problems or controlled substances problems. It's a much more straightforward analysis. Um, I want to get into one of the other ways that people get into detention a lot, though. So on the next slide, there are a lot of people in the US who have already been ordered removed, and many of them don't even understand it. If you are from a country that it is very difficult to remove you to, for a long time, ICE had a process where they would put you under what's called an order of supervision. We analogize that to ICE probation. You have to report to the ICE office as often as they say. It can include cell phone monitoring or ankle monitoring or other conditions. But it's for people who have already been ordered removed and simply cannot be removed at the present time. So we've seen huge communities of people who for decades have been under orders of supervision suddenly be targeted for removal due to policy changes, not law changes. So one example is, I think it was about 2018, there was a large group of Chaldean Christians from Iraq who had lived in Michigan since the 70s, and they had convictions that made them ineligible for permanent residence. But for decades, they were living in the US, going to their ICE check-ins with no problem. And then all of a sudden, at one of their check-ins, ICE says, guess what? We're canceling this order of supervision and we're going to try to send you back to Iraq. That can happen at any time, and so few people who are responsible for reporting to ICE actually understand the precarity of their situation. So there is some litigation that can be done preemptively. If you have someone say, I have an ICE check-in in a week or so, and I'm afraid I might be detained, that's an opportunity to look at what you can do ahead of time. So one of the things I don't like doing is math. And this issue of the 90-day period during which you shall be removed is something that actually requires calculation in a lot of cases. You can have clients that have been in and out of custody several times throughout the decade that their removal case goes on. And you sometimes have to be very specific about looking at which of those count towards the 90 days and which of them don't. So a lot of people who have already lost their removal cases are still eligible for habeas relief if they're taken into custody because ICE says we're outside the 90-day period and we're really not, or vice versa. So in any case, there are a whole variety of statutory bases to take someone into custody. But one thing we have to be especially careful about now is that the statutory basis the government is asserting can actually just be nothing. They arrest people for literally no reason, and they spend days in custody before you find out what is the allegation of any statutory authority to even hold them. So be prepared for someone to be detained and really not have any clear statute authorizing their detention. On the next slide, I'm just going to talk briefly about why this is so important right now. We saw a series of agency decisions over the last couple of years that really kind of reversed 30 years of established precedent. The main decision that you hear discussed a lot right now is the bottom one, matter of Yajure Hurtado, which was decided in 2025. What's really interesting about this case is that the Board of Immigration Appeals says, gosh, this statute that's been enacted since 1996, we've actually been reading it wrong this whole time. And the way we're reading it now is the obvious way that it should have been read this entire 30-year period. And what it really says is anybody who's not formally admitted to the US is subject to mandatory detention. That's essentially the whole thing. Now, the board does not know civil procedure, right? Because those of us who practice in real federal court know that jurisdiction is always an issue before the adjudicator. So the board can't say all of a sudden after 30 years, we're just now deciding that we no longer have jurisdiction, and in fact, we never did. But that's the reality that we're living in. I work with law students and volunteers a lot, and I tell them it doesn't matter if you're right about all of the legal arguments when the opposing party has the keys to the jail, right? Being right does not actually get your client out. So most of the people who for decades could go in front of an immigration judge and say, look, I'm not dangerous, I'm not a flight risk, let me pay a few $1,000 bond and get out, those people don't have that option anymore. Some of the really large pro bono legal services projects around the country for years were focusing on high volume bond models where you had a lot of people who were not dangerous, not a flight risk. They just needed letters from their family. They needed a little bit of logistical help. And you could kind of create a cookie cutter model where you were bonding a lot of people out. When I was managing the project in South Texas, I think we did like 40 bond hearings a week sometimes with volunteers on 4 or 5 different dockets. So now every single case where you have to get someone out of jail becomes significantly more complicated. Because now every time you go in front of an immigration judge and say, look, my client should get a bond, the judge says, I'm sorry, I'm bound by this matter of Yadri Hurtado decision. Even if I wanted to give you a bond, and even if I would have last year, I can't now. So I'm sorry, no jurisdiction. You can then appeal that decision to the Board of Immigration Appeals, but that is an illusory process. The Board of Immigration Appeals usually will not decide a detained bond appeal until your underlying removal case is over. So the agency process to challenge whether a judge does or does not have jurisdiction is completely illusory because in almost every case it will moot out by the fact that your client will be ordered removed before you get the release decision. So there's a huge class of people now where a district court in California and some other courts have said very clearly they are subject to the statute that says they qualify for a bond hearing, not the one they said that says they don't. Um, what we're also learning a lot about how the current administration understands civil procedure, because what they're saying is, well, even though we are the defendants in this class action in California, we're not bound by it outside of the Ninth Circuit. I have no idea how they're justifying that conclusion, but the government is really just blatantly ignoring very clear declaratory judgments from federal judges all over the country, and that's why these cases are so ripe for habeas. So on the next slide, habeas is one of our most important constitutional protections. It goes back to before Magna Carta. So for something like 900 years, human legal systems have said, "Hey, your personal physical liberty is so important that there should always be a way you can challenge your detention in front of some adjudicator." So there's an argument now that the writ is de facto suspended if you have a lot of judges in habeas saying, no, I don't have jurisdiction over this even in habeas. Is that an effective suspension of the writ for all of these people who, again, they're not dangerous, they've never been alleged to be a flight risk, and they're spending months and months in jail for, I would say, nothing but political reasons. So the next slide just has a little bit of practical advice on how you file these. Most of the time you file on behalf of a single petitioner. And the reason for that is because you don't know which judge you're going to get. When we started doing some of these, we thought, gosh, if I have 5 or 6 people, or even just 2 or 3 of them in the same procedural posture, it will be easier for me as a nonprofit to file this as a multi-party habeas because I don't have to serve all the defendants over and over again. Well, you can do that, but then if you get a hostile judge, you essentially have put all of your petitioners in a bad position. Whereas if you file your petitioners individually, you have a better chance of getting different judges, some of whom might be more favorable. They try so hard in law school to convince us, right, that it's the law that matters and not who's wearing the robe. But we know the truth is it's who's behind the bench that matters more than what the law says. So in the Sixth Circuit, the Court of Appeals has said that the immediate custodian is the ICE field office director. So you only technically have to sue the ICE field office director, but there are lots of reasons why you might still want to sue the sheriff or the head of the Executive Office for Immigration Review or the DHS secretary. The issue is just that when it comes to doing the summonses, the more people you name, the more you actually have to generate and serve and mail all of the summonses for. So we'll talk about some of the other issues regarding venue and administrative exhaustion later. But for now, I think it's time to turn it over to Russell for the 1225, 1226 legal theory section.
Thank you, Brian. And these slides that'll we'll cover over the next few minutes grew out of a habeas project that we have going on in Michigan, collaboration between the ACLU and the Michigan Immigrants' Rights Center. And it has been designed to make it as easy as possible for people to be able to file as many of these habeases as possible, even if you have no experience in federal court or no experience with immigration or no experience with either. We've put together template habeas petitions, briefs, reply briefs step-by-step guides on how to file these things on Pacer, and we have a listserv, and I host office hours twice a week just to go over questions relating to habeas petitions or bond hearings and the removal cases. And I think a lot of those materials would carry over well to attorneys in Ohio that are looking to file habeas petitions in Ohio, other than perhaps needing to update some of the case law. And you may also see some individuals detained in Ohio transferred up to Michigan to our North Lake detention facility in Baldwin, Michigan. So there's some overlap there as well. Immigration attorneys we have our own parallel sets of citations. So you may hear me refer to these statutes as INA 235, 236, and 241. But I'll do my best to refer to them by the U.S. Code citations that are listed here. And when we file our habeas petitions, we refer to the Federal Code section rather than the Immigration and Nationality Act section. So 1225 is the detention scheme that governs people who are seeking admission into the United States and are being detained. 1226 is traditionally understood to govern the detention of people who are already in the United States. And then 1231, as Brian mentioned before, is for people of the final order. You can put that statute to the side for now. It's the first two that we'll talk about more now. And we can go on to the next slide. So the three types of habeas scenarios that we've been encountering that come within this 1225, 1226 rubric are people who entered without inspection or entered illegally, in other words, more than 2 years ago, and were first encountered or detained by DHS more than 2 years after their entry. That's the matter of your Hurtado group. Then there's the matter of Q Lee group, which are people who were encountered or detained by DHS at the border or within 2 years of their entry, even if they were released and are now being redetained more than 2 years after entry. And then finally, there's individuals who were paroled into the U.S. either at a port of entry or after being detained at the border, and they were released on a parole under 1182, 8 USC 1182 D5A. In Michigan, all three of these scenarios are treated more or less the same by the habeas judges in terms of how they're being processed and the outcomes. If we can go on to the next slide. So here's 8 USC 1225, and I highlighted the key phrases in section B2A, and that's where all of the litigation in these habeas cases are what it's addressing. That if someone is an applicant for admission and they're seeking admission, they're subject to detention by DHS, and immigration judges have no jurisdiction to review their custody status. Only DHS can release them, and only via a parole. At least that's how the agency is interpreting it. And an applicant for admission is defined also in 1225 as anyone who's present in the United States without having been admitted or parole. In other words, anyone who's entered the United States unlawfully is treated as an applicant admission. So most of the habeas litigation really hones in on the seeking admission phrase. If we can go on to the next slide. On the other hand, 1226 provides as a default that a non-citizen who's detained while inside the United States is eligible for a bond hearing in front of an immigration judge and a bond determination on the merits as to whether they're a flight risk and a danger to the community, other than where specified in 1226C, which does provide for mandatory detention of non-citizens with certain kinds of criminal history or security risks. And the new Lake and Riley Act amendments, one of the reasons why we repeated this here is Congress's amendment to 1226 by adding the Lake and Riley Act is an argument that's in favor of a grant of habeas and undermines the government's new interpretation of these statutes. So if we can go on to the next slide. And just briefly, under 1226, ICE can set a bond, and if ICE sets no bond or sets it too high, an immigration judge can can review that determination and order release on a different bond amount. Matter Guerrera is the primary BIA decision setting out the factors that the immigration judge will look at, as well as the allocation of the burden of proof, which is also a topic we'll get into later as well. So if we can go on to the next slide. So for 30 years, it's been almost universally understood that 1226 applies to individuals who enter the United States without inspection, regardless of how soon after entry or how long after entry they were being detained by DHS. At least until July 8th of last year, when in a leaked memo, the government took the position that someone who's entered the United States without inspection is not eligible for a bond in immigration court, no matter how long they've been here or any of the other individualized factors that are relevant to their situation. And why does the government think that? As set forth in matter of Yajure Hurtado, the government believes that one, anyone who's entered without inspection is an applicant for admission. That's hard to argue against. So generally, in our habeas petitions, we'll just not concede that, but just move on to the second part, which is seeking admission. And DHS and the government will argue that someone who's entered without inspection is forever seeking admission to the United States, that they're perpetually seeking admission until they're admitted or removed. But an admission is defined in 8 U.S.C. 1101 as a lawful entry after inspection and authorization by an immigration officer. And that doesn't apply to non-citizens who've already entered the United States and aren't applying for admission. If we can go on to the next slide. The government also argues that 1225B2 is not redundant read in combination with 1226A and the Lake and Riley Act amendments. But the counter is that in the Lake and Riley Act amendments, Congress specifically held that non-citizens who are present in the United States without admission or parole and are therefore subject to removability under 1182 A6A, which is the EWE removal statute, or A7, which is kind of parallel to that Congress held that those individuals are not eligible for bond hearing under 1226 if they have certain kinds of criminal histories and arrests, say for shoplifting, and that Congress would not have placed this amendment into 1226 if Congress understood 1225 and not 1226 to govern the detention of individuals who entered the United States without inspection. Otherwise, it would render that statute redundant and superfluous, because 1225 would already provide for the mandatory detention of that class of non-citizens. And then the government also argues that the legislative history is that individuals who enter the United States without inspection shouldn't be treated any differently than arriving aliens who are detained at a port of entry and not granted admission, with the latter group not being eligible for bond hearing. But EWEs, at least under our arguments, should be eligible for bond hearing. If we can go on to the next slide. The government also argues in their habeas responses that if someone is applying for cancellation or removal, or maybe adjustment of status, that they're seeking admission to the United States. I haven't seen a habeas court really go into detail in addressing that argument, but a good response to that would be that the board has held on numerous occasions that someone who's granted adjustment of status hasn't actually been admitted to the United States. The board held that recently in the context of a 237A1H waiver. They've held that in the context of whether an adjustment of status is an admission for purposes of disqualifying someone for a criminal waiver of inadmissibility under 1182H. And the board has held in other occasions that a grant of TPS is not an admission, a grant of a U visa is not an admission, or even a grant of asylum is not an admission. So the fact that someone's seeking status while they're inside the United States, and even if they're granted that status, they're not admitted for all purposes under the immigration laws, and therefore they're not seeking admission. If we can go on to the next slide. And the government also argues that due process doesn't apply, other than that an individual is entitled to the procedures that Congress has set out in the INA, and that there's an exhaustion requirement, which we'll get into more in later slides. So what are our arguments? And these are on the next slide. The big picture is that the government's position will mandate the detention of millions and millions of people who've been in the United States for years and years and have strong ties here. And it'll mandate their detention without a bond here, regardless of their circumstances. And this goes against 30 years of how the agencies apply these laws and how the courts have applied these laws and how they've been commonly understood. And the arguments that are fleshed out more in the template habeas petitions and the briefs are that one, it's contrary to the statutory language, focusing on the seeking admission refers to an inspection and admission process that occurs at the border, not a process that occurs inside the United States as part of an application for a status. This is contrary to Congress's intent and understanding of these acts, as indicated most recently by the Lake and Riley Act amendments, which place the mandatory detention provisions of EWIs within 1226 as opposed to 1225, as well as the legislative history at the time that these statutes were initially enacted back in 1996 as part of the IRA immigration reform. That it's contrary to longstanding agency practice from 1996 all the way up and past that 2025 memo that was mentioned in an earlier slide. For example, in the board decision last year, matter of Akhmedov, the board reviewed on the merits a bond denial of an individual who had EWI'd without ever referencing this issue of jurisdiction over the bond status of an EWI. In your client's own case, there may be documents to reflect that the government's treated their detention as being under 1226, not 1225. There might be a notice of custody determination or a warrant of arrest, so an I-200 or an I-286, that indicates on the face of those documents that their detention is being governed by 1226. Or maybe there is a prior bond determination from an immigration judge under 1226. And then finally, a due process argument. That due process argument is very important. In the Fifth Circuit and in the Eighth Circuit, in cases that we'll discuss in a few minutes, the courts there have accepted, the circuits there have accepted the government's interpretation and overturned habeas grants, but didn't address these due process arguments. And so that's allowed district judges to continue to grant habeas petitions on due process grounds, notwithstanding the foreclosure of these statutory arguments. So let's talk a little bit now on the next slide about exhaustion. I understand that that's a big issue with some of the judges in the Northern District of Ohio, and they're relying on that to deny habeas petitions. There's no statutory exhaustion requirement for a habeas petition under 28 U.S.C. 2241. And just to back up, exhaustion means that a federal court would decline to review an issue if the federal court believes that the agency, in this case the immigration court or the Board of Immigration Appeals, should get the first crack at it and address it. And it's only if they rule against your client that you could then seek judicial intervention. But although there's no statutory exhaustion requirement for a habeas petition, courts can decline to review a habeas petition by applying the doctrine of prudential exhaustion. And there are several factors that a court will look at to determine whether prudential exhaustion applies. Whether there's agency expertise that makes agency consideration necessary to create a complete record and reach a proper decision. Two, whether relaxing the prudential exhaustion requirement would encourage a deliberate bypass of the administrative scheme, and three, whether administrative review is likely to allow the agency to correct its own mistakes and eliminate the need for further judicial review. The decision that's cited there at the bottom of the slide, Kobix versus Raycraft, has a very long discussion of this prudential exhaustion factors, which we can discuss more in the next slide. So one argument against applying prudential exhaustion is that doing so would be requiring a habeas petitioner first pursue a bond hearing and an appeal to the BIA is futile. Matter of Yajure Hurtado and matter of Cooley binds an immigration judge and binds the Board of Immigration Appeals. So it'd be a waste of time, a waste of resources to pursue those options. Two, the Sixth Circuit has held in these decisions, including the two cited here, that the due process concerns surrounding an unlawful detention are so great that it makes it unnecessary to pursue administrative remedies, especially those that would be futile, before seeking habeas relief. A bond denial by an immigration judge, if you do have one, if the timing just works out where you've had a bond hearing, the immigration judge has denied bond on jurisdictional grounds, that should be sufficient to exhaust remedies without appealing to the BIA. But you should also be able to push and file for habeas before an immigration judge denies a bond, if the immigration judge would be bound by existing BIA case law. I understand some judges don't agree with that. And that's unfortunate because if you have to appeal to the Board of Immigration Appeals from a denial of bond, that's just going to take so long that by time it's resolved, the removal proceedings will probably be concluded and the bond issue will be moot one way or the other. So the final slide in this section is just a brief survey of some of the case law right now. The government's position has been rejected almost universally, probably close to 100% by all the judges in the Eastern and Western districts of Michigan. In the Southern District of Ohio, there's been some good results recently. Northern District, the results are more mixed. When we get to the slide, a slide in a few minutes about the option of maybe filing in Michigan instead of Ohio, I think that uncertainty over which judge you'll pull in the Northern District of Ohio comes more into play. The government has won on these issues in both the Eighth Circuit and the Fifth Circuit, but just on the statutory interpretation argument, not on the due process arguments. The Sixth Circuit heard oral arguments in 4 consolidated habeas appeals filed by the government on March 18th, and we're just awaiting a decision on that. It's also recently been argued in the Second and 11th Circuits, and I believe it's pending in most, if not all, of the other federal circuits. So in the next group of slides, we'll talk about some other types of habeas petitions that you might encounter and should be prepared to file in the appropriate circumstances. So in the next slide, we'll talk about filing a habeas when ICE appeals to the board of a decision that's favorable to your client, and they invoke the procedures to obtain an automatic stay. Maybe your client was eligible for bond under 1226 because they were admitted with a visa. Maybe your client EWE'd, they won their habeas, they received a bond hearing, they were granted bond, and then ICE appealed. When ICE appeals a bond, it still becomes immediately effective generally, and you can post the bond and be released for the duration of the appeal, unless ICE invokes this automatic stay. Excuse me. ICE can do so if they initially set no bond or a bond greater than 10,000. In that event, then they would have 1 business day to file an EOIR 43 form with the immigration court and then 10 business days to file the actual notice of appeal. That stay will remain in place for 90 days unless it's extended. And as long as it's in place, your client will be unable to post the bond and get released. Most courts have been sympathetic to habeas petitions challenging the invocation of this automatic stay on due process grounds because it gives ICE so much veto power over a neutral decision maker in terms of setting a bond. And that decision cited there is a good example of how courts have addressed these due process factors. The next slide talks about challenging bond denials under 1226A. And these types of bond denials could be bond is denied on flight risk grounds, bond is denied on dangerousness grounds. And again, this could be for individuals who entered with a visa, were admitted and overstayed, or individuals who received a bond hearing through a habeas and then were denied essentially on the merits. One due process argument that can be made is that ICE is supposed to carry the burden of proving flight risk and dangerousness by clear and convincing evidence. The immigration judge, if they're following board precedent, including matter of Guerrera, will place the burden of proof on your client. And if the immigration judge places the burden of proof on your client, federal judges may be sympathetic to an argument that the bond procedures violated due process because the burden, like I said, should be on ICE. The First Circuit and the Second Circuit in the decision cited there have reached that conclusion. Some other circuits reached opposite conclusions. In the Western District of Michigan, any habeas petition that is filed that raises a pure burden of proof allocation argument will be assigned to a single federal district judge who will review the record. And if they're satisfied that you're just challenging the allocation of the burden of proof and the immigration judge misallocated that burden, they're likely to grant the habeas petition and order a new bond hearing where the burden of proof is squarely placed on ICE. A third type of habeas petition is prolonged detention habeases, which are available on the next slide. Under 1226C, Congress has authorized the mandatory detention of non-citizens with certain kinds of criminal history. And this has been found to be constitutional in DeMore versus Kim. Under the assumption that such mandatory detention would be relatively brief in nature, that you're looking at maybe 45 days or so in immigration court and maybe 4 months on an appeal to the BIA. If detention lasts a long time, the longer it lasts, the more likely it is to implicate due process. And that could open up the opportunity to file a habeas to challenge mandatory detention based on the length on a due process challenge. Black versus Decker, the Second Circuit decision, is a recent circuit court decision finding that a bond hearing is warranted, notwithstanding 1226C based on the length of detention, as well as an Eastern District of Michigan case cited there. And then the last slide in this section for other types of habeas petitions has to do with individuals subject to a final order of removal, what we would call a Zidvitas habeas based on the Supreme Court decision that found that while there's no statutory limit on the length of detention for post-final order non-citizens, that there's a due process limit to the length. And that generally the government cannot detain someone for more than 6 months post final order, unless the government can establish that there's a substantial likelihood of removal in the reasonably foreseeable future. These habeases have become a lot more common recently. It's been a long time since I think it was necessary to file these because typically ICE would just release someone after 90 days or 180 days post order, or release someone in response to the filing of a habeas petition. But now ICE is detaining people and litigating these habeas petitions because they're much more likely now to try to remove someone to a third country. And they're much more likely to pressure the home country to accept someone with a final order. So that's the second issue that comes up here is that filing these habeas petitions, the habeas process could get short-circuited if ICE then is able to or telling the habeas court that they're going to try to remove your country to a third country. Another interesting issue that comes up is whether you can count the prior time your clients spent in custody after a final order and add it to the time that they have been in custody on this most recent detention if they've been redetained. And a lot of federal courts have said yes. So if your client was detained during removal proceedings, they lost, ICE detained them for another 90 days or maybe even 180 days, and then released them. Years go by, and they're redetained. You can argue that your client should get credit for that earlier time served. And so maybe now you can file a habeas petition after only 90 more days instead of 180 days. Or maybe you could file it right away because they already have 180 days of post-order detention in the past. And the reasoning behind that is otherwise ICE could detain someone for 179 days, release them, pick them up again in a week, and continually frustrate the ability of a habeas court to review the lawfulness of the detention. So I'm going to turn it back over to Brian now for some of a discussion of the nuts and bolts about filing habeas petitions in Ohio.
So this is the fun stuff that they never actually teach you in law school, right? I remember when I first finished law school and I was standing in a courtroom, I just passed the bar and I thought, no one ever told me where to stand. So here's some of the basic stuff about how to actually accomplish these filings. First, there are a lot of great resources online. Use one of these starter kits. The days when someone just opens up a blank Word document and starts typing to create a filing are long behind us, right? In fact, there are a couple tools I highly recommend. One is called the Form tool, and that is the free version of another one called Doxera. And these are document automation tools that you can integrate into your practice that lets you create your own sort of templates from things that other organizations have developed. So I highly recommend using the Acacia or the Vicina guide when you're starting to work out your original complaint or petition. So the next slide tells you where to file. And like we said earlier, almost all of our ICE detention centers are in the Northern District of Ohio. So you will almost always be filing in the Northern District except for your Butler County jail cases, which are in the Southern District. Both districts allow pro hac vice admission, and there are various attorneys who are willing to serve as local counsel if you're not admitted. Usually the AILA chapter is a good way to find somebody who would be willing to provide that service for you. On the next slide, the discussion is who to actually name as the respondent. And I think while technically you can just name the ICE Field Office Director, Kevin Raycraft, or you could just put ICE Field Office Director, it's probably a reasonable exercise of prudence to include maybe the warden of the jail or the sheriff or the DHS secretary or somebody else just in case. There's some interesting discussions about, what happens if you have only sued the ICE Field Office Director, and then the court issues an order that only the warden can execute. The warden wasn't actually a party, so how does the ICE Field Office Director force the warden to give effect to the district court's order? One of the big pieces of advice a lot of organizations give about habeas complaints is file them early to prevent transfer. There are cases where you might not even be sure that you want to litigate an entire habeas petition, but because you're worried that your client's going to be sent out of state where you can't do anything, there's an argument that you could file a habeas complaint quickly to try to get the jurisdiction preserved and try to get an order against your client being transferred away from his legal support or her family. So when in doubt, just use the templates, right? The templates have a lot of people on them as the respondents, and I've never had any problems when I list all of those people, other than the fact that it's just more of those summonses forms that you have to generate. So,
and Brian, I'm sorry, do you mind if I just jump in
yeah.
with just a brief discussion of both who to name and where to file? In outside of the Sixth Circuit, it's very clear that the immediate custodian and the proper respondent is the warden of the detention facility. The Sixth Circuit, in a decision called Roman versus Ashcroft from 2003, is an outlier. And in that decision, they held that the immediate custodian is the ICE field office director, which is in Ohio, it's still the Detroit field office's jurisdiction, so it's Kevin Raycraft. I name myself, I'll name Raycraft, I'll name the warden of the facility, I'll name the attorney general, so Todd Blanche, and I'll name the DHS secretary, Mark Wayne Mullen. I You can file based on Roman versus Ashcroft in the Eastern District of Michigan for anyone who's detained within the Detroit field office's jurisdiction. The government, however, will respond and argue that Roman versus Ashcroft was superseded by a 2004 Supreme Court decision called Rumsfeld versus Padilla that held that the warden is a appropriate respondent and immediate custodian. But there's a footnote in that decision that seems to have a carve out for certain kinds of immigration and habeas petitions. In the Eastern District of Michigan, some judges will follow Roman and exercise jurisdiction over a habeas regardless of where within the Michigan field office's jurisdiction the person's being detained. And other judges will transfer the habeas to the appropriate federal district court. For example, I've had cases for someone detained in the Western District of Michigan that I filed in the Eastern. The Eastern District of Michigan judge transferred to the Western District of Michigan, but then the Western District of Michigan judge dismissed all the respondents other than Raycraft under the immediate custodian rule, but then went on to grant the habeas. I think if you're in a situation where you're worried you're going to uh, pull an unsympathetic district judge in the Northern District of Ohio who's already denied similar habeas petitions, then it might be worth trying to file in the Eastern District of Michigan. If you get a judge in the Eastern District of Michigan who thinks jurisdiction should be in the Northern District of Ohio, they'll transfer it to the Northern District of Ohio. Uh, so you'll still have a chance to continue with the habeas process, but you will lose the time spent litigating this issue, really an issue of venue. But it might be worth it if you think you'd have a better shot in the Eastern District.
Yeah, thanks for adding that. That's perfect. So much of this is strategy. I think those of us who practice before an administrative agency get used to doing things, on a large scale, just cookie cutter. But a lot of these habeas cases play out very, very differently based on some things that seem like minor nuances at the beginning. So you do want to avoid a situation where you're litigating who the appropriate respondent is, and maybe that means just name everyone and deal with it later. But on the next slide, there's this, I think, is one of the wrinkles in doing all of this, because those of us who practice before an agency that has its own e-filing system, we don't have to deal with Pacer on a day-by-day basis. And the way that you create and file these documents in Pacer is actually very specific, sometimes to individual courts. So I'm going to put a link in the chat right now. The Southern District has a really good guide to how to create a new civil action on Pacer. And it's about 15 pages with screenshots of how to actually use the different drop-down menus. It's not intuitive. I don't know who designed Pacer. It gets the job done, but like in terms of all the different drop-down menus, things are never where you really think they should be. But what you really want to look at when you're filing these civil cases is Federal Rule of Civil Procedure 4, because you have to file summonses in the Ohio federal courts in order to get the opposing party properly served. So if you look at Rule 4, you basically just use the civil summons form. It's Form AO 440 in federal court. And there's a process by which you fill it out. You file it with the clerk. The clerk processes it and then returns it to you, and then you serve it on the respondents. There's actually a rule I didn't notice where if you're asking for informa pauperis status at the district court level, you actually have to have it served by the clerk or the sheriff. But the filing fee for a habeas petition is only $5, so I've never done an informa pauperis at the habeas petition level. We have at the Court of Appeals level. But so What you want to do in a lot of these cases is file and just call the clerk. I'm one of those people who hates picking up the phone, and a lot of our immigration court clerks are not amenable to being called. But in a lot of cases, it can save a lot of time if you just ask them, hey, what is it exactly you want me to do? We have had some cases where the judge will immediately issue a scheduling order. So I talked to one of the court clerks earlier today, kind of off the record, and she said, be prepared for cases where if a district court sees like a PI motion or a TRO, they can issue a scheduling order immediately without waiting for you to do anything. So make sure you're on top of your PACER notifications. The flip side is if you don't get the summons accomplished, you're trying to get somebody out of jail. They're usually sick. They usually are desperate to be back with their families. So the longer that you take to actually get the summonses all accomplished, the longer the case is just kind of going to be parked on the court's dashboard. So most of the courts will not do anything until the summonses come back as returned, so that they know for sure that the opposing party has notice. But there are these magical districts around the world. I think Georgia and some of them, and I think maybe Michigan, where the U.S. attorney has waived service, and so service is accomplished entirely by PACER. But the way we've been doing it so far, and what we've been told, is that you'd still have to file the Form AO 440 summonses in both the northern and southern districts of Ohio, and there's a special part even in Rule 4 about how to serve U.S. government defendants. So just hopefully you have a paralegal who can read that and take care of all of it for you. I'm not so lucky, but make sure that you focus on the little details in all of this. On the next slide, we're kind of running short on time here, so I will summarize the content. But a lot of cases, you'll get maybe a short status conference, or you will just get a judgment on the pleadings. Somebody asked in the chat about which judges are hostile. So Judge Pamela Barker and Judge Phil Calabrese are both appointed by the current president. They both sit in the Northern District of Ohio, and they have both said that administrative exhaustion means actually getting a bond appeal decision from the BIA. Not having the judge deny your bond, not filing an appeal, but actually getting a decision from the board on your bond appeal, which we explained to them is impossible. It will take longer for the BIA to resolve your bond appeal than it will for you to be removed to your country, but they don't seem to care about that. So that's why the strategy is much, much more important in the Northern District, because if you draw a hostile judge, you might not even get to the point where you have to serve the opposing party. The judge can just dismiss offhand by saying, nope, prudential exhaustion is required. We don't even need opposing counsel involved. You lose. And that's one of the difficult things with filing multi-party litigation is if you get a judge who's inclined to do that, then all of your petitioners are going to end up in that same boat. It looks like we only have a few minutes left, so I can just go really quickly through the next 3 slides, maybe. So most of the courts I've seen are not really willing to do a bond hearing themselves so far. A lot of the federal judges say, you know what, this is something that immigration judges are experts at. We want to kick it back to them. We're ordering them to hold a bond hearing. The cases where I've had the district court order the immigration court to hold a bond hearing, ICE has actually just let those people out because they couldn't get the bond hearing together in enough time. And that's one thing to be very careful about. If you have a hearing ordered as relief in district court, that hearing could happen very quickly without any notice to you. And then you're in a bad position going back to the habeas judge to say, well, they held the bond hearing you ordered, but I wasn't there because nobody told me. So there's a lot of, I think they're calling it second wave habeas litigation now, where you've sort of won on the merits in the beginning, but then the immigration courts have still found a way not to release your client. And then you've got to continue at the district court level on a motion to enforce or some other procedural mechanism. I think the general advice now is you don't want a bond hearing in front of the immigration judge, even though that's what a lot of the district judges want to order. The immigration judges, we reasonably suspect, have been told to find other reasons to deny bond. So we have cases where they're ordered to hold a bond hearing by a district court and sitting in habeas, and then the judge says, okay, well, now I think you're a flight risk. When any other situation over the last 30 years, a judge never would have found flight risk on those same facts. So your best case scenario is to just get the district court to hold a bond hearing itself or order release. That's an open question, though, as to how successful you will be given which judge you draw in that, though. So the next slide talks about how, yeah, the government could schedule a bond hearing really quickly, but they will still try to find a way not to let your client out. So I like to describe immigration court as the place where even when you win, you don't win because there's always some other wrinkle or something else coming down the pipeline. For those who don't practice in immigration court, it is formally called the Executive Office for Immigration Review, and we do call it EOR because, like the Winnie the Pooh character, it's a huge bummer and nobody leaves happy. So I think that's the end of this section. There are some emerging trends, but we can skip that for now.
I think you covered these already. I don't think there's enough time to go through the remaining slides, but they include links to helpful resources on how to find your client, how to contact your client, how to check the status of their cases, and then links to the Michigan specific materials. If anyone's interested in or has a client that's being detained in Michigan, but the case began in Ohio, or you just want access to the template habeas materials. I think they're easily modifiable to any district court.
And if you're new to habeas filing as part of one of these bigger volunteer programs, I think it's one of the best ways to get involved and learn how to do it. Hook up with one of these case placement or volunteer lawyer programs and learn how to do it that way.
Well, thank you both for your presentation. We did get a question come in. I don't know if you guys want to, I'll read it aloud and let me know if you have any thoughts. I have a case where there are serious due process violations with the dismissal of a case. There was no advisement to a lawyer contrary to statute. The client had no lawyer, and he did not understand the difference between dismissal and a disclosure. He had an I-130 pending. Do you have any straight up due process law other than criminal cases?
The primary framework for analyzing a due process violation in an immigration matter is the Supreme Court's 1976 decision in Matthews versus Eldridge. And there the courts look at three primary factors. One, the private interest that's affected by the agency action. Two, the risk of erroneous deprivation of that interest. And three, the government's interests, including fiscal and administrative burdens, that the additional procedures or the substitute or additional procedures would entail.
Now, we've argued Matthews versus Eldridge in the context of a petition for review before and said, look, this pro se Senegalese rare language speaker deserves to at least have some idea of what the heck is going on in this whole process. And the Sixth Circuit didn't go for it. So I'll just, you take that for what it's worth. I don't know if there is actually a due process right for a respondent to know what's going on in removal proceedings, even though there obviously should be.
Thank you. I don't see any more questions that have come in, but thank you both for delivering such a great presentation. Um, Everyone, I will send the materials out to you just after we conclude here. Let us know what you thought and what else you'd like to see coming out of the international law section or just any section or practice area you might want to see programming out of. It looks like, yeah. No more questions have come in, so sorry, I just saw a notification. All right. So with that, Adrian, I don't know if you have any final thoughts on the topic. No, it looks like we're all set here. So Russell and Brian, thank you so much for your time and your energy, and we hope to work with you again soon.
Thank you.
Thank you.
Have a good
Have
week,
a
everyone.
great afternoon, everyone.